enye easy pa enko de video no. Kevin Taylor my analysis on the court issues will and in some be the KNC. My person was over the brain. I was face and some so. God bless you.
Chairman, who will be Kachayana?
Bessie, I'm a new one. The match is going to be good money. Don't worry. I didn't want no match. I will have that. I don't have that.
Chairman, who will be Kachayana?
Come on.
Chairman, who will be Kachayana?
Come on. It's my floor. Bessie, I'm a new one. The match is going to be good money. Don't worry. I didn't want no match. I will have that. I don't have that.
Chairman, who will be Kachayana?
Apia could be guy again. And also, Muda Mofankan, Moye read them Fankan near Twaso, and the judge allowed that to happen. 3 times, these people have abused the court. The judge did not say anything. The judge wanted the case to flow. The judge did not want to be seen as biased. Judge Bia said, he or she would not even entertain this nonsense. He would just move or she would just move. But this judge, na otra court intro on person be the no or person delay case no na yanko enim. The name on this witness statement is not one of the names listed in the list of names of witnesses filed by the accused person. It is not for nothing that the practice direction on case management provided those direction to be taken. Or see, enyekwa say ye case management conference. The reason tia case management conference and then say send ye beya Attorney General person or the prosecution witness ba wa apia kubi ubehu nipa kro ubehu omudin ubehu nipa dodo send beya wo so apia kubi what the prosecution accused witness ba yesu ubehu nipa kro ni din o say enye sa kekenti na CMCO botai bi tare chire na sa wo beba court na ya meet na wie na betena court na de adefo fraba means wo no court no person bebu court no. It's not judge no to appear could be for say they are all or say case no neni da ho no obu court denim tia. He is disrespecting the court like deliberately. Now already document where a court document you can go and ask, they will give it to you and media. Now say obesa will follow proceedings say see court after this something happened. The same court I mean really they see in chiro Mekaba be see the attaching so the same strategy appear could be taking and no be no taking the disrespecting of the court, abusing of the court, say court more opportunity to pay, they'll blow it up. Oma MPP lawyers way appear could be an attaching way 2 days obe said man could do 2 months. That is why we have to be careful because court you don't allow these things to happen. The moment we give room for that, other criminals, their lawyers or their counsels, that is what they will be doing. Ochina omoko court nte enyumbre menya abota medwudwa we mu akiro. Now, when you move ahead, this is what it says. The bedrock, I wanted to read this is the latter part of the second one. Change in circumstances to cause a witness to be changed, substituted, and added. It is for the accused person to seek leave of the court, giving reasons for saying, and not the situation this court is confronted with presently. Judge Nika say, we are accused, lawyer, who appear to be. That's what person was a witness. And now open say witness be changing the D and now we in the D film and now obi fufu beshema. You have to follow the right procedure. Unim send ye no court ya. But what appear could be a say Obeka say Kevin Taylor na ebet na adakem ade abechi ye beba no na Kwame Amoako ye busa na Or see when the agenda case in the uncommon Kevin Taylor. Inti judge ni kachen said that thing now appear could be no good court in the oh disrespect court no. In fact, court ni chance or the amount say the lawyer for Chama Wontumi not to me a protector and I said defender no. It is looking like say what the sa opportunity no, what the abuses our opportunity no. It's judge ni call point to explain to him say sa. Adia wo yen enye wo na wo ma case ni delay because we are not supposed to do these things. What the witnesses list ba also making sure so we so but to me court now witness list e bia yira obi din nim enti na judge na kire say dey adwuma say court mra no ho wunim dada so obese say obi krampa there is a way you do it. There's a way you go by it, but you just don't appear in court and say may change way without any formal approach to it or formal a way to approach it. It's not judge and say no. What is going on? Who say case no? Who disrespect the court no? Who abuse the court no? Now, mommy uncle so any uncle who dey see your court. Now, the bedrock in criminal trials, Judge Nekasano, the bedrock in criminal trials is fair hearing. However, this should not be translated into an abuse. Inti judge say, "Hey, apia ku bi ni chema Wontumi nti ase. Nyoma ma ebebrea mama mo chance a sebio mu bu court ne ebomfia, mo disrespect court no, mu delay case no. O say, saa nyoma na media mama say Wontumi emfa nka mo asem no enkyere say mu betumi ebu court ne nimfia ana abomfia, mu betuma disrespect court no. O say de mi wi kyere say saa na mo pese mo ye. Or say yema obi fair trial yema obi ho kwan say ono so en defend no ho onfa kofombra be defend no onfa adanse fombra be defend na say court ma ho kwan na court enya abotre na court anya okeke en kire say ubetum the court ni metwitwi form it judge ka say wo apia kubi woni Chema Wontumi ene sa eye the accused person ade a mo ye no emwaye sa nyama we nyina si wo court. Did you ever hear Apia Kubi come out to say court no did you ever hear the Attorney General come to say, this is what is happening in court? Apia Kubia abuse court. No? The Attorney General did not have time for that. The Attorney General's job was to get a witness to cross-examine, was to get to the bottom. If there are there are things happening in court, Ubi abuse court. Now, it is not for the Attorney General to say. The Attorney General can raise objections and raise concerns in court, but the Attorney General, it is not his duty to make sure, an accused lawyer follows rules and regulations or court proceedings, the regulations. It is the court. Until right now, the judge is talking. The judge is frustrated. The judge has seen, Apia Kubi, any Chema Wontumi no, almost shut down on person who go court and say, delay case, no, until all the way from May, they started delaying this case. So, case where attaching Abesomi, nan can you say through June? So case when can say enter June, Apia Kubi ade oyeye because from day one, not almost strategy. Delay the case, delay the case, delay the case. Now, Judge Nesaka Saya or say the bedrock of criminal trials is fair hearing. Now, at this juncture, Judge Nekasa Muntieno. This is all the way in May. The judge started getting frustrated with Chema Wontumi Apia Kubi. All the way in May. Now, Judge Nekasa say. At this juncture, the court does not know whether or not the witness statement it has received in the name of Honorable Evans Adai is an addition or a substitution. At a point, now, I say, Apia Kubi akofa statement for Fraba. I feel like the court now confused. Evans, Honorable Evans Adai, now oka witnesses no. I feel bayani dinim. Afia saba court Apia Kubi akofa sa nipa na no asem de abase yemfa asem we hye na je say right now dey na wo ye no list out the brain na ko edi wom afia pie court na di nim yesa wo court wasa akofa statement bi abase e yakwa ne statement ki judge say onim say or substitute akwa na free case ni mo say o de obi be hye mo right now the judge was confused e dey na Apia Kubi ye no e dey na Chema Wontumi ni Apia Kubi I so money da ho na o ma ye say o mo be book court nim ti o me delay case no. This is May. And remember, before May, no my assignment way na be my judge and bibia. But you see, anytime they walk out of court, no matter catch case there, bibia judge na do some time. They knew what they were doing from day one. Deliberate delay of the case. I idea from day one. Na omunim di omoye. Now, when you move forward, judge say, I do not think this sort of practice assists the court in the smooth delivery of justice. Judge say, I do not think this sort of practice assist the court in the smooth delivery of justice. Or say the appear could be no, and the chairman want to moya court. There be no makase, no mu delay court, no more. Or say sad the way are moya no. Menya sure say mo pese court no e di the juma send you say di the juma. I say mo ti mu pobi say court juma di no be say no. That is the statement of the judge. So the judge got an idea of what chairman Wontumi and appear could be no more ye. And it's now one person no master no say me who say mo ye bibi say mo pese mo say case no mo pese mo delay case no unnecessarily mo pese mo shada na case we no eye tintia na nipa ehun say de ekọ judge no got frustrated. Remember Adewe has been going on for 5 months. The judge did not say anything. But it got to this point now. Feel appear could be too much. Appear could be the other court, no. And you see, say judge be our body timu possible be the bonnet. Now or time chairman want to make a case we can do me. Anka case we no. Anka say by a match. Now say judge no. But you see, the judge and the court accommodated all these things. These are documents. These are some of the things they did. Now, Judge Nicole Nimno, Judge Nicole Mokasemi or say CMC, Case Management Conference, is to give direction and clarity to all parties in the matter and above all, avoid surprises. Or say, Sa CMC no mo a Case Management Conference no ni nyina say yebeko court ochna. Krata bi Attorney General Edeba bebusa Chairman Wontumi and the other accused or say Attorney General the judge in front of a year appear could be enim. And as appear could be so and a baby sebu or better to a year Attorney General witness and one. I was saying Krata or Busanina or the banner judge who send a bear yen quarter or bink of a Krata befra bontinimba Emma a Attorney General because appear could be Krata with the one fan so Busami witness once. Or say CMC the Nijuma Dian. Na ya den yakwa CMC ni ebeba na apia kubi ashada dan no won say de onim say CMC na odin krata foforo nipa din foforo statement foforo o say sa nyoma na apia kubi ye no wa shada. Now uku edima judge ni sakasa I say so when an accused person in the middle of a trial without leave of the court decided or decides at will to change witness in improper and this is stated with caution to the accused person, the 1992 Constitution grants rights to all persons, especially in criminal trials. However, these rights should not be exercised in a manner that will degenerate into a pattern of abuse of the rules of court. And judge ne kachire eye de o kachire eye apia kubi ene chairman Wontumi say munim bibi. De mo ye nyina sebio 1992 Constitution eka se nipa bia wo kwan se sebio yenka ne kashaboa enhye ne yem obetumi aka na adwene obetumi edefend no ho obetumi afro obi amana ba abeya adansefo amano o se your constitution kire se obia wo kwan se sebio obenya fair trial obetumi aka na adwene aka no nokre ma yetie no o se na saa de na ewo ho constitution mu no saa eye tumi na constitution e de amaye se Ghana fo yebetuma fa lawyer yebetuma ko gina court yebetuma ka se oh sebio we de menya hwe nipa we no wo bi we na madanse for no o se saa to be na constitution na Ghana ni bia no o se opeso o ma apia kubi ene chairman Wontumi muti ase se from nyoma o ma ye a o ma sheda ebu court nim tia ebu eye de constitution nim tia ema apia kubi continuously wa sheda eye de abuse court no see saa nyoma no sebio so muti ase se ade bi o maya o de ni atofo mehu se e follow pattern bi ade bi ade se utumi tena hu se we ni ade bi o ma form ho adwene se o mo beye o se saa de na den o mo eya abaye o musuban ene o musu no sebio ono oya judge no ohu ni pay face se apia kubi ene on person obebu court no chairman Wontumi a oya accused person a wakofa apia kubi no o ma bom tirimu po se court no obebu court ni mtia o mo de court ni twitwi fom o mo be say asem no o mo be slow asem no judge na asem o kan no say ah saa nyama amu yi e wo be constitution defend obia but I say they said obia hu tirimu po de mo ye makama no atum ahwe wa we apia kubi we panyini why a lawyer che but I say wa hyeda se o pese obu court ni mtia me judge ametie me nipa and also me tie obi asem but I say from time ongoing time coming no why say adia why ya no na saade na wo ye no e kire pefe se wunim de wo ye why why say obebu court ni nimtia These are judging words, and yet these are not my words. Now, Judge Nicole did not say, having cautioned accused persons. Now, this is what the judge concluded on. Now, court concluded on this. Having cautioned the accused person, so it means that the judge actually cautioned Apia Kubi. Cautioned Chairman Wontumi. Said, you are abusing the court. Court na mamu found kakra se mo fandi modwuma no mo pese mo de eden ebu court denim tia. Enti for a judge to caution you, it means the judge has had enough. For a judge to say dear mo ya no muntwa so. Mama mo time too much, and from proceedings you didn't see Apia Stadium. Apia Kubi object to it. Apia Kubi never objected to the statement the judge made because no one said true, and the judge did not say anything out of what is happening in court. Saying Apia Kubi, the judge nekano, Tananka judge ni chatra. Apia Kubi would have objected and say, "My lord, this is not true. I never did this. I never did that. I will never." But you see, because Apia Kubi knew what he was doing. Because Apia Kubi don't say or person delay case no or person abuse court no or person disrespect judge no or person judge ni bufu na judge de no, he knew what he was doing. Anything a judge no question or said the omo ye no a follow party be omo no, Apia Kubi didn't raise any objection. Now, having cautioned the accused persons, the court will exercise its discretion and adopt the witness and the witness statement as if the witness was listed as one of the witnesses and conduct CMC on same. Inti Apia Kubi, omudi honorable ada any statement in the baya. Na at the end of the day, na nkeni say Apia Kubi the far back door, the be court ni kaso ni bibi. Apart from all the things you have done, inconsistencies, abusing of the court still judging say magic in the statement, Mesa Abba CMC. So the judge was not even supposed to do it. Because one, the witness now Apia Kubi edebano. In the first place, where you witness the dear film, and in the second place, the statement of that background, Sebio now witness didn't sign yet, and the Paul Sanka called, and so judge Nikasoni Bibi. Upon all the disrespect, must show me or court her to delay the case, still, remember the chance, come to CMC, that is Case Management Conference, and come show me. So you see, upon all the disrespect, Apia Kubi show judge, still the judge gave Apia Kubi that respect. Upon the basic deliberate mistakes he did, they're deliberate. They make it look like it's an oversight. It wasn't an oversight because judge not told judge before. And Apia Kubi Debi Okacham say, "Oh, you're experienced lawyer. He knows what he's doing." So the judge knew from day one what Apia Kubi was doing. But you know what? Anka judge Bianco about the timu pose or Chema Wontumi anka that day and anko be in the case. Yeah, because those were not Apia Kubi and not Chema Wontumi, not only witnesses biabim. But I saw what the judge did. The judge said, "Still, I will give you the opportunity. Remember my chance. Somebody Evans Adai we can one. No problem. The statement from nowhere, we don't know where it's coming from. No, I'm going to adjourn my case, meet you at CMC for you to explain to me, for the Attorney General to be there, for we all to understand each other, and come back again and put that person you want to put in the box for cross-examination." The judge still accommodated this guy. The judge on the case still accommodated. You see, in law, you don't allow perception to take over facts. And especially when it comes to in criminal cases, when it comes to politically exposed people, when they are standing criminal trial, especially when you have an opposition that can create accusation out of everything. We have people who don't really follow facts. When you're a judge on a case, what you do is you give people the benefit of the doubt. It does not make you weak. It's what it does is that it makes everybody understand out of your courtroom, because and you'll be in a raw courtroom. What it does is say that leniency, that room you give people you even think are abusing the court. When you do that, what happens is you make the case more transparent. You don't give people the room to go out there to insinuate, to create an impression, because you see, perception, when it's attached to a crime or a case in court, it basically dissolves the potency of the case. So I think what this judge was doing was that she didn't, or he didn't want to give anybody any room to say the accused person is being treated unfairly. Even though there were some things that this judge was supposed to stop, there were some things this judge was not supposed to entertain. A lot of abuses and disrespect to the judge herself or himself or the court, the judge was not even supposed to allow. For some reason, Because the judge wanted Ghanaians to understand that this case in court is not personal. She has no personal issues, or he has no personal issue with the Attorney General or even the accused. And that the judge's main focus was to make sure that this case, at the end of the day, whatever the accused has to present, they present it fully. And whatever the prosecution have to present, they present. So the judge was basically avoiding that perception that the accused person is being mistreated, the accused person is being gagged, the accused person's lawyer is not given the room. But you see, but the more lenient, the more diplomatically lenient the judge is, the more advantage Apia Kubi and Chairman Wontumi were taking of the court. So you see, now when you give people the room to protect themselves, you give them the room to basically be heard, they abuse it, they take advantage of it. So we are judge and Kaden and Kobe. But all these things happen in court. All these things happen in court. None of us was told about this. But these people are the same people. Right now, what is Atachia doing? Atachia is doing the same thing. But I'll go back to the ruling. About what happened in court. Nobody will accuse anyone of being hard on anyone. And it's all and I will study there. My dear, you can see clearly say from day one, Apia Kubi or Shadan or abuse case, or abuse court, and a delay case, Now, shall you see Judge Nicasari, Apia Kubi Ekasaya, what did he say? I have a friend in Canada. He just texted me. He just told me say I should call the witch doctor Kukubunzam. Canada for any day. Xavier Kukubunzam. Xavier, I'll call you after the show. Now, Judge Nicasari, Apia Kubi also responded to what the judge said. Eden Okaye. Or say, counsel for A1 and A3, that is Apia Kubi. Or say, we have a witness statement of one Honorable Evans Adai. It was filed on the 28th of May 2026. I pray that the said witness statement be adopted by the court as a witness statement of the said Honorable Evans Adai. So, formally, I feel na all catch the judge and say, sir, witness na. Judge Niko CMC some time back and dioma Apia Kubi muyi free muno. Afe na Apia Kubi kase afe na the witness no edi ban in statement inti yanko CMC ni yanko discuss biem. So you see, anytime I'm going to say if Apia Kubi had an issue with the judge's pronouncement on the delay tactics, on the disrespect and abuse of court, and Apia Kubi be raise an issue and say, Your Honor, or whatever, your lordship. In fact, what you are saying, without due respect, is not true. But you see, Apia Kubi didn't say anything because what he has done, abuse the court, what if the judge did not have that patience, was not professional enough, has no interest in the Obika, just focus on the case, and a judge in a react and press conference and Apia Kubi. Imagine the judge threw out this their witness statement out to say we have gone to CMC and that we came to court and you're giving us a different thing. Count him the Apia Kubi. Do you know the kind of impression Apia Kubi Chairman Wontumi they would have come out to put? Count him the Kofi Benton Babakano Abontene. Count him the MPP dogs. Do you know how they were going to narrate that? But you see, the judge being an honest judge, not wanting to take sides, listening to everybody's piece, the judge still gave them the opportunity. And anything appear could because, Madam Judge, Mr. Judge, please, now we want to formally drop the witness statement. The court should adopt it. We should go and have CMC. Remember, Sankadia or Yen first, meaning the case has been dragged back again. This is all the way in May. They delayed the case for about 3 months, no reason. Now, so that is what happened in court. Makacho said this document, if you want to get it, go to the court. It's there. These are court documents. Now let's come to what happened in court the day Apia Kubi. The day Apia Kubi called court. Eko kachre judge and say onye lawyer today. Chairman Wontumi biom. Now, you see this. Right now, the abetted is attaching say or court in court. Didn't know court or pray for 6 weeks. 6 weeks in any day, or see if be witness written submission or written addresses. those submissions, no, you did asem we are. Lawyer Bia Odi a client enim no. You will share your opinion on asem na utinemu a lawyer for somebody no. The accused lawyer etnim etro and I said the prosecution lawyer no. Now judge no a really a year appear could be case no that day no. Because that day na appear could be called court so oko catch court to say on your lawyer to chairman Wontumi bi no. Judge ni tie ni nsem nyina no. Na appear could be argument nyina say judge no entwentwen so. Because we you know free say on your chairman Wontumi lawyer bi no. Chairman Wontumi ko fa another lawyer until ma judge no emfa the judgment mba. Anything
What is it? Politics is always same.
Every day, in the moments we love, we rely on clean and safe water that flows from Polytank.
For choosing us. Well, this afternoon, the Office of the Attorney General has mounted a stronger opposition to an application seeking to delay judgment in the ongoing criminal trial involving the Ashanti Regional Chairman of the New Patriotic Party, Bernard Entry Bosiaku, popularly known as Chairman Wontumi, over alleged illegal mining activities at the Samre Boy concession. His newly appointed lawyer, Samuel Atachan, filed a motion at the Criminal Division of the Accra High Court, asking the court to postpone its judgment to allow him sufficient time to familiarize himself with the proceedings and trial records before filing his written address. Legal Affairs correspondent Fatau Bayaga has more in the following News Desk report.
According to court documents, Samuel Atachan argued that a sudden change of counsel at this critical stage had left the accused persons without adequate legal preparation for the final phase of the proceedings. He also invoked Article 19 of the 1992 Constitution, arguing that the accused persons are entitled to a fair hearing, which includes effective legal representation at every stage of criminal proceedings. Mr. Atachan further told the court that despite filing a notice of appearance and requesting certified copies of the case records, the registrar had not yet made the documents available, limiting his ability to review the proceedings. He maintained that the application was not intended to delay justice but to ensure adequate preparation and fairness before judgment is delivered. However, the Attorney General's office has asked the court to dismiss the request and allow the case to proceed to judgment. According to the prosecution, a 13-paragraph affidavit in opposition was filed on Thursday, June 25 by Senior State Attorney Nana Ama Prempe. The affidavit argues that the application lacks merit because the accused persons had legal representation throughout the trial and the withdrawal of their former lawyer was voluntary rather than the result of circumstances beyond the counsel's control. The prosecution further contends that Mr. Atachan's decision to seek the case records directly from the court registry instead of obtaining them from the previous lawyer was not made in good faith. It therefore maintains that the application should be dismissed so the trial can proceed to judgment without further delay.
Well, let's explore this further here on The Pulse. Join me now is lawyer for Chairman Wontumi, Samuel Atachan. We appreciate your time here on The Pulse. You're asking the court to postpone judgment simply because you have only recently taken over the case. Why do you believe this is even necessary at this time, knowing fully well that the AG says that they're done and dusted with this case?
Well, then what is the point of filing addresses if they are done? And if you go to the law, I mean, the accused person is entitled to address the court. The law says so clearly. And right now, there is a very serious climax of the case that we shouldn't play down at all. The man is bereft of counsel. The whole state, the Republic of Ghana, is represented by the Attorney General. Why is the state represented by the Attorney General? Because of the power of counsel. The Attorney General is going to urge upon the court that Wontumi should be imprisoned or convicted. And now the individual is having no counsel. But the Attorney General is going to address the court. and file processes to divert. Why should we not have fair trial that I should also study the proceedings critically and then aid Wontumi and submit that the case is not proven beyond reasonable doubt? For that matter, it should be acquitted and discharged. And why are we in an ambulance mode relative to the liberty of the individual and fair trial as enshrined in the Constitution? I can't come to terms with that.
But he has always had legal representation. Andy Apiakubi has been his counsel. And the Attorney General argues that your application is already coming in at a time where he feels it's only to delay the proceedings. And so I'm wondering how you respond to those accusations.
Why should anybody say that we want to delay the proceedings? Now, do you expect a carpenter to remove the tooth of a patient, or you want a dentist to do it? What is more critical here is that the law says that he's entitled to address the court. And how do we address the court? Unless I internalize, the proceedings that have gone ahead of me. I don't have a clue about the case. So if the Attorney General is insisting that, let's close the door to the accused person in terms of addressing, the court, and then I will have the opportunity to address the court, that's an unfair prejudice to the accused person. And I can't understand why the Attorney General will not give a little space to the accused person so that we address the court. And whenever the judge is ready, after having listened to arguments from us, the judge will come out with this decision. That is what justice is all about. I thought we have a Ministry of Justice. Is that not so? Or we have a Ministry of Prosecution. So if you are in an indecent haste to have the case done at the expense of the accused person, then what justice are you ministering to Ghanaians? I believe the Attorney General should see his role as a very fair player in the justice delivery system, rather than saying that, we are ready, we believe we are going to have convictions, we believe, what kind of, advocacy is that? So I will make my points very clear that by operation of law, if you want to have fair trial, there's an opportunity that the man should not be bereft of a lawyer. They should have the benefit of counsel. I'll look at the proceedings, and then I'll write out my submission for the consideration of the judge. After all, the outcome of a case is more serious for the accused person than the Attorney General. If you look at the balance of hardships, a man hasn't gotten the opportunity to, address the court. Probably by some error, he goes to jail. How do you compensate for it? And how is the state going to suffer if we are given a couple of days or even weeks to come out with a credible address? To aid justice. How is the state going to suffer? I can't understand that.
But at what stage did you assume responsibility for Chairman Wontumi's defense? Because we've always known that Andy Apiakubi has been representing him. He tried to withdraw his legal counsel. The court did not permit that. And so why exactly is there a need for a change of legal representation at this point in the proceedings?
Well, subsequently, I don't know the technical issues that visited the application for withdrawal of counsel, but I got to know later that, he filed it. The process that is out of the case. So, madam, a critical matter is that, can you do a serious legal work as an individual who has no legal training? When the Constitution talks about the right to counsel, what does that mean? That means in critical matters of this nature, a lawyer should represent you. And how can the lawyer do any competent job? Unless he comes to terms with the proceedings. And is it too much for a lawyer to study the proceedings, marriage with law, and write out a very competent written submission to aid justice, and then the judge will consider. And then you believe that it's only the Attorney General who should write a one-sided argument for the consideration of the judge. I think it will be to the disadvantage of the accused person. And that will not be in.
If he says he cannot work, it's personal service. It's rendering personal service. He's using his skills, etc. So once Apia Kubi says he can't continue, he has to be let go, and then a new one take over. And when the new one takes over, he needs a bit of time.
I see. Let me bring back Samuel Atachan. I want to find out from you, beyond the procedural issues before the court, are you even confident that the evidence presented so far during the trial supports your client's innocence?
Well, Madam, I don't want to pretend that I have clairvoyance, but I'm telling you that as counsel people is saying, it takes a professional lawyer to internalize the processes so he will know what to do. So I've not read the processes. I just got the full gamut of the record yesterday. So I'm going to spend some time with it. But for me to be afforded the opportunity to peruse the record and advise my client and or file a written submission is in aid of fair trial. Because I've urged upon everybody that, look, even the state or the republic is having a lawyer. How much more an individual? So what is the understanding of the balance of justice, where the state is being represented by a whole attorney general, but the individual is now bereft of lawyer when the case has climaxed? And Martin will agree with me that this is the most important point, where you summarize the proceedings, marry it with law, and make submissions that the case has not been proven beyond reasonable doubt, which could sway, it doesn't always happen, but it could sway the judge that this man deserves an acquittal. How can anybody say that this is not too important to be considered by the judge? So I'm very surprised that even the Attorney General filed an affidavit in opposition and say that we are trying to delay the trial. But then, if you don't give us the opportunity, and then we don't shed light on the case from our perspective, and the man suffers miscarriage of justice, how do you compensate for it? Just a couple of weeks could be fine for us to put it across. People go to the Supreme Court and they ask for extension of time. So justice is ministered. And it will be seen by the whole world that, look, even the judge said, I've given you a little time, put across your case and let me consider it. That is fair trial and justice. But to shut the door on his face when he has no lawyer, I don't believe that will be justice.
But the Attorney General maintains that the trial has already run its course and that all parties really have had the opportunity and ample time to present their case. And so what exceptional circumstances really will justify a reopening of the process at this stage?
Yes, the exceptional circumstance is the law, Act 30. I don't want to argue the law here now, which says that the accused person is entitled to address the court. It's a whole statute. So therefore, if the lawyer is no longer with him, how can a lay person address the court and write written submission? I'm very glad that, my colleague has been a very prominent person in a justice delivery system. Everybody is quoting him, Martin Pebu. It's all because of justice. How can you expect a lay person to address the court? And therefore, I'll be pretending that I'm an Einstein in the law, that within, 2 weeks, I'll be able to read the entire record and write a credible written submission. I shouldn't be pretending that I know too much. I should take my time and look at it. So I'm not saying that the judge should not deliver the judgment. I'm saying that by reason of the circumstances and me coming in lately and at the climax of the case, you should give me the opportunity to play this role, all in the interest of fair trial, as enshrined in Article 19.
Because how much time really do you need, realistically speaking?
Well, I don't have to say everything here. I'll urge it upon the court. And the court, the judge also understands how long it takes. I mean, for a lawyer to, excuse me to say, put together a credible written. So when she should ask me, I'll ask for some good time, a reasonable time, so that everybody will see that I'm not trying to delay the process. But I want to, with the greatest of respect, defend my client in accordance with law and shed light on the case from my perspective.
And what would be reasonable and good time to you? 3 months? 2?
Oh no, it won't be 3 months. At all, it wouldn't be 3 months. But I think we will talk about reasonable time when I'm before the court.
I'm interested in the reasonable time. At least it can help us plan ahead. Even as journalists, we want to know, is a month okay for you?
It's not about the 90 minutes. It's what you put into the 90 minutes. It's not just about the win. It's about the will to win. It's not just about the jollof. It's about what's inside. This advert is FDA approved.
It's not just about the game.
It's what you put into it.
Well, if you push me, 6 weeks will be fine. And the realm called Ghana will not cave in if a citizen of this country is given 6 weeks to put together a credible written submissions. It will not affect the inflation in the realm. It will be consistent with fair trial and criminal justice, that an individual with no professional training, cannot address the court, and the guy said, I'll give you some allowance because you were a Johnny just come. Familiarize yourself with the proceedings and write out what you think is the position of the accused person. We are not asking for too much.
And we know that this case has attracted a lot of public interest, especially because of the allegations surrounding illegal mining. How would you ensure that your legal strategy really remains focused on your client's constitutional rights rather than the political attention surrounding the case?
Well, I believe it's because of the political tensions that sometimes it's making the Attorney General run faster than is required. Because sometimes they want to play to the gallery and satisfy constituents. But when it comes to justice delivery, madam, it's not how bad Galamsey is or how terrible it is, which will be the underlying factors to deal with an accused person, but the law and the evidence. A man should not be sentenced on the basis of public sentiments. Martin knows what I'm talking about, as to how they feel about it. But as to how the law as put together by the Attorney General will ground a case which has been proven beyond reasonable doubt. It is not Galamsey that is going to rewrite our Evidence Act for us, that prove beyond reasonable doubt when it relates to a criminal matter. No. The law is independent of the feelings and the sentiments of the general public. If not, then I'm afraid we'll be tried in the in the court of public opinion, and people will be guilty before they are sentenced. And that is terrible indeed for the nation. That will not be upholding the rule of law. But then we are whipping the sentiments of, some constituencies and political people who believe that, you've been here for too long and if you not secure warrant, imprisonment, relative to our opponents. That is not law at all.
Stay with me. Let me bring back Martin Pebu. The AG's argument is simple. This case has run its course. What is left now is judgment. If the court dismisses the application based on the arguments being made by the AG, what are the likely next available legal steps that the defense team can apply?
Then they would attempt to arrest the judgment on the day it is to be delivered. So let's say on July 3. Now, do we see that July 3, it appears would be a public holiday? So that means that ordinarily it may not come off. Yes, you see, the courts have held in table number 4, there's Attorney General number 4, that the court can sit on public holidays, etc., right? Yes, so if the court wants, it can sit. But a lot of the time, if it's not a bail matter, very, very urgent, the court may say, under the rules, actually, the court will sit on the next working day, which will be Monday, July 5th. Now, so on the day, whether July 3 or it will go to July 5th, there is what lawyers call motion to arrest the judge. So the day the judge is going to give a judgment, the lawyer can file a motion. Let me use ordinary words, an application to the court to stop that, not to give the judgment because of some reason. Now, to put it simply, even though the court can throw out that last-minute application, what happens is that last-minute application is usually filed last minute, from its name last minute. So you will find that at the time they will be before the court, the Attorney General will not have a copy, the court will not have a copy. But the lawyer, accused and his lawyer, so Wontumi and his lawyer, can show their copy to the judge. And once it's shown that it has been filed, then it means they have to postpone the case a bit to consider the reasons for which Wontumi wants to stop the court from delivering judgment. And even on the return day, that's the day it is finally dealt with, even if it's thrown out, then there's an opportunity to go on appeal. So actually, legal gymnastics, there are not to be deployed. But it's heartwarming to hear Atacha saying that it doesn't need more than 6 weeks. Now, we can say this, to move the law forward, right, to get all of us, we are a nation. I like the statement made that Ghana is not caving in the next 2-3 weeks. We'll be here for centuries. We will even die and go, and Ghana will be here. So based on that, if he goes in with a request for 6 weeks, I'm sure they can negotiate and then come somewhere in between, middle of the road. Because when I say middle of the road, the court will go on vacation on 31st July. I've not checked. Is it a working day? If it's a working day, then that day the court will work. But if it's 31st falls on Saturday, then it means that the last day will be 30th.
My name is Benjamin Asari, last star goalkeeper. World Cup will come and go. Even set matches will come and go. Birthday, family gatherings, all will come and go. But you must get only one trust, that is politics.
If you can have somebody check which day, 31st
I think 31st July is a Friday.
Very good. So that's the last day the court will work, and then the court has to go on a break. So till, let's call it roughly 10th of October. There's a way to calculate it. If I calculate it, it will waste time and maybe some people will not follow us. So now, this is what I'm saying. So within August, September, some special courts will work. When I say special, meaning a few courts will work to deal with only urgent matters. So let's say, what's your name again? Is it Jema Ofori? Or what's your name?
Say that again.
Hello? I said, what's your name? Let me give you your name for an example.
Faustina, cancel.
Faustina. Okay, Faustina, Safo, good. Now, Faustina, assuming somebody wants to take your child away, your husband wants to run away with your child to the U.S., and it's 1st August or 10th August. That one, we cannot wait till October. So there is a way your lawyer can run to court, and then they will seek to stop him. So what I'm saying is that in the months of August and September, up to about the 10th of October, thereabout, it's only very urgent matters, or somebody is building on your land, etc., but not to give judgment like in the Wontumi case. So that's what I'm saying, that so we have up to 31st July. So when a here goes in and they negotiate, anytime before or on the 31st of July, it's possible. It's possible because he says he needs 6 weeks. Maybe he goes and is able to persuade the judge. The judge may say, I'll give you 3 weeks more. It may come in the middle or 3rd week of July. Or worst case scenario, the 4th week of July. Or there's also the other option that if he wants to give an undertaking that he will agree to the judge to apply to the Chief Justice for extension. So I told you that the August, September, up to the first few days of October, we don't do such judgment in criminal cases. Others we don't do. If he wants to agree that he insists on the 6 weeks, which will take him into August, then in that case, if you agree that they will apply to the Chief Justice that they should do the judgment in August, everybody will be there. We are a nation, good faith. And the judge can come and deliver in August. But otherwise, August, September, and the first few weeks of October, it's holidays. We don't do this type of business. That's giving judgment in the criminal case. And let me be clear, when I say holidays, that's High Court, Court of Appeal, Supreme Court. And even those ones, they do urgent cases. And I'm saying this judgment is not the type that is called urgent. Unless Atachia agrees that he will come to court in August, and then he will agree and write to the Chief Justice, then the judge will apply, and then it can be done.
I see. Stay with me, Martin. Let me bring in Samuel Atacham to find out your next line of action. You are pleading for 6 weeks. If you don't get 6 weeks, what will be your next line of action?
Madam, I beg to remain silent on my next line of action because I don't want to, with the greatest of respect, practice the law in advance. I'm hoping, and I'm praying also, that the judge should have exercised the discretion in our favor that any person before the criminal court who has a right to counsel, and the right to counsel straddles the entire trial till you get the address, and the man has no lawyer at the climax of the case, giving us a little accommodation will not shortchange the state. I believe the judge should see through this and give us the space to do some good work, all in the ultimate interest of justice. Because at the end of the day, people will also be saying that, why is the judge depriving a man of the opportunity to present his address as enshrined by law? What do you say? Do you want people to say that, oh, the judge was jaundiced against Wontumi, and when he was disadvantaged because he didn't have a lawyer, he ravished the whole situation and gave a judgment? So I'm afraid it is not that simple, but I'm very excited this hour that as always, Martin's sense of the law is sound. And I'm very, very glad, because sometimes people believe that, oh, we are just playing with situations, we want to delay justice, but that would never be a delay of justice. As a matter of fact, it's going to advance justice. A man's address was put together, and the judge looked at it and came to one conclusion or the other. That is what we are praying for.
Well, some people are of the opinion that the NPP would be electing its chairman soon, and we know that Chairman Wontumi, he's vying for that position. So this is simply delay tactics, just to buy him enough time to contest and, if possible, win that seat. How do you respond to those concerns?
It will be a lottery of a projection to think that Wontumi will be the next chairman. We don't know. And even if you look at all these matters that he's grappling with, we don't know the outcome. But madam, in as much as people might want to project politics, which they love to do, one thing I will say, this country is a nation where we should uphold the rule of law. A man has been arraigned before a competent jurisdiction.
Laureate graphite powder tumbler screening machine.
Big news. Starting January 1st, 2026, Masters and PhD no longer need PAL. That is, there's no need of provincial attestation letter. This change applies to students attending public designated learning institution. So, if you wish to study in Canada, contact Say Home Canada Immigration. Remember, your study journey can open doors for your family as well.
And I'm of the view that every accused person, whether he has political proclivities or not, is not the matter. What is the matter is the law. And the law is saying that he can address the judge. Now he hasn't gotten a lawyer. Let's put MPP aside. We are praying in aid his right to counsel at this climactic stage of this case. And if somebody believes that, oh, let's read politics into it so that he becomes the chairman, that is his own permutation that I won't take from him. But as far as I'm concerned, we are not urging anything MPP on the judge. It's only the law. and we are going to do so forcefully.
Your final words.
Well, I pray to God that because we have the rule of law, as even enshrined in Article 19 of the Constitution, talking about fair trial, the Attorney General is representing the Republic of Ghana in the case. The ordinary citizen of Ghana hasn't gotten a lawyer to aid him write a written submission. I trust God that even for even balance and equity in the law, the judge should give us a space so that we put our case across. That is our humble prayer, and we're going to urge upon the judge to do so.
Thank you so much. Samuel Achacha is lawyer for Chairman Wontumi. I'd like to wrap up with Martin Pebu. Your final words.
Okay, well, so it's all right. What I'll say is that, as Achacha said, he will not dabble in the politics. Just to remind citizens, you see, sometimes when people of his party, I'm not going to the politics of it, but it's important. You see, people of his party started ridiculing this administration that Ora is dead, Ora is dead, Ora is dead. You see? So now, today, he needs more time to study brief. But because there's political pressure from citizens that Ora is dead, you see, it has put Wontumi's case in a bind. So when politicians set out to, cause disaffection for a government in power, sometimes it's better that they think ahead, because we think which political case have they ever seen? Remember those days, various governments come in 1.5 years and they are done. Some of the cases, the people who were convicted, Ibrahim Adam and Co, Kwame Petra, the NDC people those days, 2 years, 3 years. But this one is what? Just about a year, and they are done. You see, so the caution is to the people who seek to make political capital out of everything. You are ridiculing the ruling government. Ora is dead. Ora is dead. Now, Ora is about done with one of the cases involving Ashanti Regional man. And the lawyer brings disaffection needlessly. You see, in our trade for power, it's facing now. Otherwise, ordinarily, this request Attaché is making, it's not any extraordinary request. It's not difficult, easily, but for the political course, this thing could have gone into October. Like I told you, because we are going on vacation, it could have been adjourned into October. But some people have caused the fact that Ora is dead. That's how come this is causing all this tension, that they will not agree for Attaché to spend more time studying the brief. But like I said, I believe at the end of the day, they will find middle ground so that something can be done, so that he can get more time, but before 31st July. Or, like I said, he always want to improve the law. So if he wants to improve the law, he should give an undertaking. At least they should last to November thereabout. Because as I mentioned, can be qualified. I mean, in this case, we can agree that they will do business in August. Then they can finish in August. Yeah.
Thank you so much, Council, for your time here on the Pulse. We are still watching the Pulse. Stay with us. When we return, angry NPP supporters demand immediate dismissal of former flag bearer aspirant Kennedy Ejapon.
Not every big account grew by luck. There's a secret behind the scenes.
You need to click now.
If you want your content to reach thousands, try Widers.com now.
Luxury night stay at Aqua Safari, scenic river tours and boat cruises, fish and tortoise feeding experience, underwater cave viewing, eco park adventure with amazing wildlife encounters, buffet meals, island party with live band entertainment, swimming pool, archery, board games, lawn tennis, endless vibes from our DJs, and fun activities for the kids too. So bring along the entire family. Rates are going for 4,000 Ghana cedis single, 6,000 5,000 Ghana cedis double and 10,000 Ghana cedis for a family of 4. Book now or make enquiries by calling or WhatsApping Lois on 053 100 3813. The Joy Safari Escape, June 20 and 21. Joy Safari Escape, one weekend, endless memories. The Joy Safari Escape is powered by Hits FM and Joy Prime.
To dance with my father again.
Another week is here on the greatest of all time show. My name is Giovanni Clip, and tonight we're bringing you talent. Contestant number 1, let's bring Baby Car. Let's bring. You did it for you.
Cut. Oh, there is a leakage.
Where's the plumber? Where's the plumber? For quality and durability, insist on Syntex pipes.
If you want quality, this be where you belong.
Strong, tough, and reliable. Your perfect match to your trusted Syntex pipe. Syntex pipe, it they carry water, no wahala. Syntex pipe, it they make water they flow. Syntex, and you're strong, and you're tough.
Mom, so Kitty Rice contains all vitamins?
Yes.
And snacks?
Absolutely.
Kiddivite Multivitamin Tonic. Kiddivite Multivitamin Tonic contains all the essential vitamins and nutrients needed for the healthy development of children from age 1 to 12 years. Also available, Kiddivite. Grow strong. Grow healthy with Kiddivite. Distributed by NS Chemist Limited. This advertisement has been
that can be produced locally. That is why this June, Joy Business and the Super Morning Show, in partnership with the Federation of Associations of Ghanaian Exporters, FAGE, bring you the Joy Agribusiness Month 2026 under the theme From Soil to Sovereignty, Building Ghana's Agricultural Self-Reliance Through Innovation. Join us on the Joy Super Morning Show, Joy News, and a security and agribusiness future. Week 1 focuses on government policy, trade and financing for food sovereignty. Week 2 explores research, innovation, mechanization. Week 3 examines infrastructure, value addition opportunities across key horticulture value chains. The final week looks at consumer power and Ghana's roadmap to food sovereignty by 2030. Stay tuned to Joy FM and Joy News. Did you know that Ghana currently spends more than 8 billion Ghana cedis annually importing food that can be produced locally? Agribusiness Month 2026 under the theme From Soil to Sovereignty, Building Ghana's Agricultural Self-Reliance Through Innovation. Join us on the Joy Super Morning Show, Joy News, and across Joy Business platforms for a month-long national conversation on Ghana's food security and agribusiness future. Week 1 focuses on government policy, trade and financing for food sovereignty. Week 2 explores research, innovation, mechanization. Week 3 examines infrastructure, value addition, youth participation, and agricultural financing, while Week 4 highlights opportunities across key horticulture value chains. The final week looks at consumer power and Ghana's roadmap to food sovereignty by 2030. Stay tuned to Joy FM and Joy News.
Let me share my wildlife experience with you at Safari Valley Eco Park.
Welcome to Safari Valley Eco Park.
Our electric shuttle pulled up and in no time our tour began. We were surrounded by wildlife from the moment we entered the Eco Park. We were greeted by experienced tour guides who took us through orientation and how to better enjoy the experience. Watch these animals roam freely in their natural habitat undisturbed by our presence. We saw zebras, sable antelope, brown cranes, mara, silky chicken, nyalas, Shetland ponies, and so many animals I just couldn't keep up. Our tour guides taught us so much about the wildlife, their behavior, and how to interact with them. I even fed them. We also went fishing on a man-made canal. Then we took a break to have lunch in this serene environment. All this amazing experience for this price for adults?
This price for teenagers. This for kids.
It's a bargain, as the sun began to set, it was time to go back home, but not before dinner by the campfire. It's been a thrill of a lifetime, and I can't wait till my next visit.
Safari Valley Eco Park, bringing you closer to nature.
Numerous cases of people falling asleep have been reported across the African continent. No one can explain this phenomenon.
With 24/7 FIFA World Cup coverage, sleep can wait. Everything can wait.
Catch all 104 matches from as little as 98 Ghana cedis only on GoTV.
Did you know that Ghana currently spends more than 8 billion Ghana cedis annually importing food that can be produced locally? That is why this June, Joy Business and the Super Morning Show, in partnership with the Federation of Associations of Ghanaian Exporters, FAGE, bring you the Joy Agribusiness Month 2026 under the theme From Soil to Sovereignty, Building Ghana's Agricultural Self-Reliance Through Innovation. Join us on the Joy Super Morning Show, Joy News, and across Joy Business platforms for a month-long national conversation on Ghana's food research, innovation, mechanization. Week 3 examines infrastructure, value addition, youth participation, and agricultural financing, while Week 4 highlights opportunities across key horticulture value chains. The final week looks at consumer power and Ghana's roadmap to food sovereignty by 2030. Stay tuned to Joy FM and Joy News.
The city had one of its most dramatic years in recent memory. It opened 2020.
Thanks for choosing us. Well, this afternoon we start in Parliament, where the Speaker of Parliament, Alban Babing, is forcefully rejecting suggestions that Parliament became functus officio after passing the controversial anti-LGBTQ. His comments come days after the Communications Minister and co-sponsor of the bill, Sam George, argued that Parliament's role effectively ended once the bill was passed and transmitted to the President for assent. In fact, the Majority Leader has also insisted that Parliament's job is done. But speaking during the courtesy call by a delegation marking the Supreme Court's 150th anniversary celebration, Alban Babing maintained that Parliament remains and retains a role in certain circumstances and that established procedures exist for the bill to be reconsidered. Listen.
Recent debate where some lawyers came out strongly to say that by the Constitution, once a law is passed on the floor, Parliament is functus officio. It's not the law. Because we have what we call post-passage process before you send it to the President for assent. And that process gives the opportunity for Parliament to reflect on what it has passed. And that is why in the Constitution, there's no time limit given to Parliament after passage to submit to the President for assent. And on many occasions, we usually identify some inconsistencies of rescission to rescind the decision of having read the bill the third time, and then use that to do it. In fact, we are very soon going to use it in connection with the Ghana Investment Promotion Authority Bill, which was passed in March. And so we have that process of self-regulation or self-correction. And when you now go through that, we also don't do it alone. We also have even the assembly press, where you need to do the gazetting. And so our process we do here is called markup process. And then it's now sent to the President. So some of the bills, in fact, all the bills are to be signed by the clerk. And those deal with financial bills and all private members' bills, after him, they have to be sent to me. And have to go through it and make sure that everything is in order before I sign it, and then direct that it be submitted. The Constitution says presented to the President for assent. The Speaker presiding says, understand.
Well, let's explore this further. Join me now is our Parliamentary Affairs correspondent, Kweku Asante. Kweku, the Speaker appears to fundamentally disagree with the argument that Parliament has exhausted its mandate, especially with regards to the LGBTQ+ bill. But I'm wondering, under the standing orders, what process could potentially bring the legislation back before the House, and who would have to trigger it?
Well, Faustina, you are right. The Speaker of Parliament, clearly on the floor and outside of it, has been consistent in his opposition to the bill as has been passed. In fact, he has cited some provisions which he claimed were not adhered to, for which reason he wants that bill to be brought back. But as we fact-check him, that is clearly not accurate. He made a claim about the standing orders not being stood down for the third reading to happen. That was not accurate. We fact-check him on that. But of course, the standing orders provide for rescission of decisions of Parliament. Every now and then, Parliament takes decisions on the floor that have been passed. Because there have been lawyers who have consistently made the point that in their view, once Parliament passes a bill, it becomes functus officio. Where the Speaker there clearly disagreeing. In case Parliament decides to go on that route, it is possible that this may be challenged in the Supreme Court or another forum. We'll get to see what happens. But the standing orders provide for decisions that have been taken in the House to be rescinded. But it's an elaborate process. It has to go through a formal motion. The motion will be debated. The pros and cons of that motion will be debated before a vote will be taken on this. And this is where it gets a bit crunchy, because the majority leader has been clear that as far as he's concerned, this bill has been passed and Parliament does not have any more work to do on this. If he sticks to his ground, that will mean that there will be no votes in terms of the numbers for this decision to be rescinded. They have 189. If he whips all his members to say we are not rescinding that decision, that will not happen. So it's a long game yet. We'll get to see which member of Parliament will take the Speaker's invitation to move that motion. We expect that will likely be a minority MP, perhaps Reverend John Ntimfo to do so in the coming days. We'll get to see what happens with that. But there's clearly a path, a rescission, a motion, a debate, and then a vote.
I see. Well, we'll look out to how that will pan out in Parliament when the House reconvenes and looks at that. But beyond the anti-LGBTQ controversy, the Speaker also used the occasion to push for significant reforms, especially in Ghana's justice system. What changes is he proposing?
First, he talks about the appointment process. He is very concerned that the appointment process as we have it currently is not fit for purpose. He's endorsing some of the recommendations of the Professor Kwesi Prempeh-led committee for some aspects of the appointment process to be looked at. In particular, he looks at himself and says that as Speaker of Parliament, there is a certain view that he may have been appointed by the President. He says that is not the case, and that although the President may have a certain view or hand in the process, he does not appoint him as Speaker of Parliament. And that is why he's able to checkmate the President every now and then. Listen to him.
We don't need to be allowing other people to be appointing who should be a judge or who should be the head of the judges and that kind of thing. I mean, they should have the opportunity to do it themselves. A profession should have the opportunity to do it. After all, here, who appoints us? Is the Speaker appointed? Are the MPs appointed? No. We are elected. And I am elected by an electoral college. You see? But in the minds of the populace, I mean, they still refer to me as appointed. And I have to keep on correcting them that I'm not the President's appointee. No, I am not. the Speaker is not appointed by the President. The President will have a say, but that say doesn't mean that that will be the decision of the House. And we've seen it in this House, at least in my case in 2021. The President's say did not carry the day. So it means that really the Speaker is an appointee of the members, that's the House. And so I owe my loyalty and allegiance to them and to the nation. I don't have to listen to what His Excellencies and the rest will do. They don't dominate. Yes, I can listen to them because it's part of the conversation. But I will not bound by what they say. And I think that I have tried in that respect. It's not easy.
Kweku Asante is still with me. Kweku, I know he also touched on the powers and especially the jurisdiction of the Supreme Court. What concerns is he raising?
Yeah, they're currently under the arraignment. It's almost as of right. Most cases are appealed up until the Supreme Court. And he says that jurisdiction of the Supreme Court is too expansive. There are so many cases that should not end up at the Supreme Court. They should be terminated perhaps at the Court of Appeals or the High Court. And that it has burdened the Supreme Court with so much cases that really should not have ended up there.
We've seen as at now that the Supreme Court is being turned into like an ordinary court. All sort of cases are being pushed to the Supreme Court, which is sort of lowering the value of the Supreme Court, not being supreme. It's now a court of litigation, where people go and, there are some kind of things that must end somewhere and not come up to the Supreme Court. We need to look at that, and definitely there must be much thinking into it. There should have to be conversation, and then we synthesize the ideas and come up with something better, particularly now that we're handling the constitutional review process.
Well, away from that, NPP Ashanti Regional Chairman Bernard Busiako, popularly known as Chairman Wontumi, has formally sought a plea bargain with the Attorney General in his criminal trial over an alleged 4.3 million Exim Bank loan fraud case. Well, a notice filed at the Accra High Court by the Deputy Attorney General, Dr. Justice Sai, says Wontumi's lawyer, Andy Apiakubi, requested a plea deal on June 5. The application was made under Section 162C3 of the Criminal and Other Offences Procedural Act. And Chairman Wontumi were told that Chairman Wontumi and Chairman Wontumi Farms Limited and the second accused, who is Thomas Busiako, remains at large. They are all standing trial over the facilities secured from the Ghana Export-Import Bank in 2018. Well, prosecutors allege that the loan was obtained for a large-scale farming project after documents were presented indicating that Wontumi Farms had secured 100,000 acres of land for the venture. Well, let's explore this further. Join me now this afternoon is Chairman Wontumi's defense lawyer, Andy Apiakubi. I appreciate your time. I also have with me lawyer Martin Pebu, just to look at the legal ambiguities. Well, I appreciate your time, gentlemen. Let me start with Andy Apiakubi. Confirm for me, indeed, has your client formally entered into a plea bargain with the state with regards to the Exim Bank fraud case?
We have initiated proceedings.
Okay.
To begin a plea bargaining agreement discussion. So at this stage, we have asked for commencement of negotiations with the hope of arriving at a plea bargaining agreement. This is the position we have.
But what is prompting this move at this time?
Again.
What is prompting this move at this time?
Look, under the law and Section 162A through to R of the Criminal Proceedings Act, as amended, an accused person
may apply for a plea bargain agreement. And this is what we have done. And it kind of shortens criminal proceedings. And indeed, under the law, there are various expectations that an accused person may have under a plea bargaining negotiation. And one of it is probably to reduce the first charge. And one also is to withdraw a charge against an accused person, as in 162A. So we have entered into the agreement, hoping that one of things results happen. And in any case, I've seen a lot of people talking about whether you are pleaded guilty or not guilty. But under 162C, and in particular reference to 2A, prosecutors shall, before the commencement of the plea negotiation, inform the accused person of the right of the accused person to be presumed innocent until proven guilty. We are saying that we are now presumed to be innocent, and that notwithstanding, we still want to negotiate with the Attorney General to come to a conclusion that will be a win-win. And this is all we are doing.
But then I'm wondering, you're seeking a plea bargain at this point in time. Is this a subtle admission, especially by your client, that indeed he was in the wrong?
No, this is not the case.
Okay.
When we are saying that at this moment we are deemed to be innocent, and in any case, the law allows for any time within the negotiation, any time within the prosecution. So at any time that we opt to plead for bargain, there is no presumption of guilt. So we have not entered into any admission of guilt. So we are saying we are taking advantage of the law that allows for negotiation on plea with a purpose going into the negotiation. And we are not saying that we are seeking an agreement between the parties to bring in the matter to a close. That is all.
But if your client pleads innocence, why not go to court and argue your case out?
This is part of the court process. This is part of the way that the court will come to this. Because once the agreement is raised, the agreement will be filed as the judgment of the court.
And I'm wondering, what specific terms are you going into this negotiation with? What are you expecting to deliver, and what do you expect the state to do in return?
We are about to commence negotiations, so it won't be fair on the part of the party for us to be talking about expectations and decisions when we have not been commenced the negotiation.
But has the Attorney General at least indicated willingness to negotiate with your client?
We have applied for the facility. And we are
you have to speak louder for me, Andy. I can't seem to hear you. I'm struggling to hear you. So you have to speak louder for me.
What I'm saying is that we have applied for the facility under the law. And it is for the Attorney General to give us a response. So I cannot answer the question you are supposed to be, because I am not the person to provide an answer to this.
Stay with me, Andy. Let me bring in lawyer Martin Pebu. I'd like to start with some education, legally, especially because some argue that once you enter into a plea bargain with the state or whichever case you're in, it's a subtle admission of guilt in the face of the law. What's your thoughts about that? What does the law say? Martin Pebu. You have to unmute for me to hear you clearly. Oh dear, we're trying to reconnect our lines to speak to lawyer Martin Pebu, but I have with me anti-corruption campaigner Vitus Azim. I'd like to start with your initial reaction. What does this mean for the fight against corruption?
Well, it doesn't actually help the fight against corruption, because if you can illegally take money and then at some stage you plead to pay back and the state accepts you to pay back any sanctions, I think that doesn't help the fight against corruption.
And we're yet to know the details of this plea bargain that they're pushing for. But then you say it won't help, especially looking at how many cases before Chairman Wontumi. Isn't this the wisest thing to do?
Well, it's a very difficult decision for the government to take. Because sometimes you look at, if we forfeit all this money and we go and lock up the person himself or in jail, and then the state continues to feed him and take care of him in jail, what will be the benefit? So you have to weigh that against the money that you've lost and the effect it will have in the fight against corruption. But that's a very difficult decision that the government will have to take on behalf of the state.
And moving forward, should we encourage more of such deals?
As I've just said, I think we should not encourage it, but sometimes if there's no way out, you see, because when you encourage it, then I can take government money to go and spend, maybe build a house or invest it in something, and in 3 years' time you start a trial and I go and plead back and then pay back the money, maybe even with interest, but then I would have had the benefits of my investment. And see, so that is the situation. We shouldn't be encouraging it. But then if there's a situation where you think that that's the best way for the state, maybe you may have to accept it, but it shouldn't be something that you encourage on a regular basis.
And you say it must not be encouraged, but is there anything civil society can do, especially anti-corruption campaigners like yourself, to discourage the state from accepting plea bargains?
Well, it's advocacy to put pressure on the government not to accept it, and to insist that government should be transparent in the conditions for that for accepting that plea bargain, so that everybody will see that there's good reason to accept it, or there's no reason to accept it. At least that is meeting us halfway. Although, as I've said, we shouldn't encourage it. But then, like I said, sometimes there are certain situations you have no choice than to accept it. But then let people know why you are accepting it.
But should we also consider changing our laws, because the law clearly provides a provision there for anyone to enter into a plea bargain?
No, we shouldn't change the law. I think the law is necessary. As I said, in certain cases you have no choice than to accept it. So why change the law? But the law provides some discretion on the part of the state. So the law should remain as it is, so that the government can take a decision based on the individual cases, the merit of each individual plea bargain.
And from your point of view, especially when you say that we should look at the cases based on its individual merits, which kind of case do you feel that it's okay for us to go into a plea bargain?
I have said that, for example, if the money is so huge that if you don't accept the plea bargain, you forfeit all that to the state, and then you send the person to prison for even 10 years. It may not be wise enough to do that. You may have to look at it from that point of view.
Okay. Vice, stay with me. Let me bring in lawyer Martin Pebu at this point in time. I want to understand some of the legalities involved in this. Legally, some people argue that once you enter into a plea bargain, it's a clear admission of wrongdoing and guilt. In the face of the law, is that the case?
Not at all.
Okay.
It depends. You see, it depends on when. So your question was that when you enter into one, so meaning that what can be the outcome of a plea bargain? Now, when you ask that question, there are different outcomes. One of them, the one that would directly answer the notion that it means the person is guilty, is that the charges can be withdrawn. So based on the plea bargaining, it's a negotiation. Depending on what you show the Attorney General, the whole court case can be cancelled. All right? So charges withdrawn. Of course, when you get to court, you would show the judge. The judge has a rule. So what you've shown the Attorney General, the judge too will take a look. But what I mean is that bottom line, the agreement can result in the whole case being withdrawn. So it's not always the case. But I think the most popular ones are that, and that's the law. So we are talking about section 162, all right, from the B, C, D up to R, right? You see that the law also provides for reduction in sentence. So let's say that if the sentence was going to be, let's say, 10 years, depending on what you bargain with the state, etc., they can agree that, okay, let's do 5 years. What are some of the things? Let's say maybe one person is being caught. The other people are not known to the Attorney General. And perhaps those people are even the kingpins. So if the underling, if the courier, if the small boy brings up the kingpins, the bosses, yeah, you can even, sometimes they even say, look, charges withdrawn. The small boy will be used as, when I say small boy, because in Ghanaian parlance, small boy is well understood, so that we will do effective communication. So the small boy will be used as what? A prosecution witness. Do you remember even the same Chairman Wontumi, his other case, the not the Tano Nimre Forest case, the other one, Samurai Boy, you know, yes, Samurai Boy. You see that his aid was used as a prosecution witness. You see that the state is no longer prosecuting the aid because they know that the aid, yes, so the one who knows you well, if we use him, we'll get better results. So come on, stop prosecuting the small boy and then rather use him as a prosecution witness. So that's one example. So the point I'm making is that a plea bargain can result in total withdrawal of the charges. It can result in a reduction of the sentence, okay, etc. They are all there. It's a whole litany. So we don't make up our mind that the moment there's a plea bargain, then it means that the person is automatically guilty. No. So apart from the ones I've mentioned, withdrawal of the charges, reduction of the sentence, the punishment, yes, okay, that's all right. These are the three key areas or outcomes that you get from a plea bargain.
But looking at this case in particular, for those of them watching right now on all our platforms, social media and on television, and you probably haven't been following the case, I'll give you a little background before I come back to Martin Pable, because we want to understand if this is the right thing for the state to go into, looking at the amount involved. Well, Wontumi Farms allegedly applied for a facility of about 19 million in 2018, claiming it had secured some 100-acre land for a farming project. Now, Ghana Exim Bank actually approved the facility and gave him about 18.7 million, that's Wontumi Farms, and also more than 14.3 million was reportedly disbursed. Prosecutors actually allege that the land was never secured, and that's why the case is before the court right now. We've heard from Vitus Azim saying that looking at the quantum of money involved, cases like this, we should not even consider a plea bargain. I'd like to get your reaction, Martin Pable. Looking at the money involved, is a plea bargain the right stance for the states to even go into in the first place?
Yes. In law, let's do this. In law, you cannot look at any case and exclude it prima facie. That's on the face of it, just looking at the figures, and you say, don't do a plea bargain. No. I like the way Mr. Azim put it. You see that his answer is nuanced, but he also went on. You see, you pushed him several times, and he said, no, he's not asking for this repeal of the law. Then he also said that he knows that it depends on the discretion of the Attorney General. Then he also made another salient point that but inform the people why you accept a plea bargain. So that is it. Okay, so we can't exclude any law, any particular sum. In actual fact, I can't wait for the state to take the 30 million back. It's good. If anything at all, Chairman Wontumi has at least 2 other cases pending before him, and it's likely that there may be other cases against him in future, because when the MPP was in power, he was all over. I won't be surprised that after these 3 cases, there will be more cases against him in future. We kept baying for his blood that no, he had done many things wrong, right? So don't be in a hurry. A person who has 3 cases, one of them involves money. Oh, take the money quickly, close that one quick. So I support the plea bargaining 150%. Yes, overzealously supporting it, because look, for Snasafo, you see how many trees, schools under trees we have, how many hospitals don't have beds. You see the Afarawa Hospital. I can't wait. I still don't believe that the Afarawa Hospital was not opened. So we need money such as this to go open that hospital so that people don't die. All right? And let's also remember that we are not the first to pass this law. Oh, many countries all over the world, the countries we aspire to be like in the UK, US, etc., they've long had these laws. And ourselves too, we had these laws in, let me use the word crude. Yeah, they were not sophisticated, but we've always had some. That if somebody does a murder, he can agree to plead to manslaughter. The most famous case is Ohinijan. Ohinijan was president of GFA those days, but he was involved in killing somebody, murder. He pleaded to manslaughter in the 70s or so, right? So the Ohinijan case and many others. So we've always had plea bargaining. We've always had plea bargaining. So it's not as if Wontumi is walking away free. No. The question is that when we get the money out of him, the question will be that if he hadn't done anything wrong, if the money belonged to him, would he have been returning it? So don't underplay the effect of the naming and shaming. It would also go very far to deter other people. You see, to go very far. For instance, as you said today, chances that somebody who has done plea bargaining and returned money coming to say he will marry you and you would accept will be very low. When we were small kids, that's why they used to tell us that, hey, if you get involved in any crime, you go to jail and come back, no woman will marry you. That was a way of grooming young men to behave, etc. And it's still there. There are some homes. The moment, even sometimes just the fact that you've had a police case, not that it's resulted in any conviction, etc. You see parents objecting to the marriage, etc. So please, let's not underestimate the plea bargaining. Once we take the money, it's also punishment, because the key thing is that why did you have to return money? Why did you give us money? Are you Father Christmas? If Wontumi has money, he will go and give MPP delegates. Why would he give government of Ghana 30 million, etc.? So I can't wait. We should receive the money quickly. Let's do the plea bargaining quickly and then move on.
But then looking at the other cases Wontumi is facing in court, it's not financially related. It has to do with illegal mining. Should he also be considering going into a plea bargain with the state?
Oh, yes. Yes. Because as you said, it's not financial. So, and considering already that one of his aides is testifying against him, etc., then it means that those ones, he can plead guilty, then you get a softer jail term. Because remember, for illegal mining, for Ghanaians, the minimum, for Snasafo, minimum, the judge cannot take you one day generally out, is 15 years. That's if you allow the case to travel to the end. And the judge is very kind, you've been, or not just really kind, but let's say the person before the court has done so many things for society, he's not well, all those things. Illegal mining for a Ghanaian, the minimum sentence is 15 years. So if the person goes to do plea bargaining, it's possible it can come to 5 years, 10 years, even 3 years. Yeah, because every time I see illegal mining and the sentence, I'm like, hey, this is really hefty. 15 years, you see, by laws, if a person is given 15 years, he will not serve all, he will serve 2/3. So you divide 15 by 3, you'll get 5. So you do, so it means that 5 is 1/3. So 2 tests is 10 years. So you serve 10 years. Then the other 5 years, the state would give it to you as a gift. That's remission of sentence. So I'm saying that, so that means that if you are given 15 years, you'll be in there for 10 years. But if you go and do plea bargaining and you get 5 years, maybe you should take advantage of the same law and plead guilty in the, what do you call it, the Samra Boy case, because that's the one that's gone further. The Tanonimri one is the one we reported, civil society, Ken Ashibe and I, and Kwame Sepoisi, the rest we reported. That one is further behind. So there are 2, but nothing stops him from doing the 2, so that if he takes the 2 all at once, it will be better. Then he gets closure.
But should we consider really amending our plea bargain laws just to specify the kind of cases you can go into a plea bargain with the state, especially looking at the concerns being raised by civil society groups that some people can be emboldened to steal from the state and then quickly run to the Attorney General for a plea bargain?
No. You see, the ones that involve politicians, that's even the very... Don't forget, I'm coming to the list. There are a list of offenses that are excluded. But let's make this point well. I've forgotten the cases the Attorney General had to discontinue the trial, the NDC appointees. You see, people were not happy. Myself, I wasn't happy about the one specifically about said they will continue investigations, because for the Sagleme case, we want to know the money that was used. Did we get value for money, or we are due some balance from Collins Dowd and Co? So that one, we will respectfully remind Dr. Ayine that he promised that an offense related to public elections. So these ones, we've said that we don't want to use plea bargaining. You see, we don't want to do plea bargaining for this. So at least this is a good attempt. But let's make the point forcefully that actually the return of the political money is the more reason why plea bargaining laws should exist. Our laws are not that strong as of now to get all of these politicians in jail. Let's just remember the cases that the Attorney General had to discontinue. These are people who had... I'm not talking about the merits of the case. I've not said anybody is guilty, even though as for the Godfrey Dami one, we heard the tape, so we could assess the evidence that Atuforsen and Japa were not guilty. It was political witch hunt. Ufuriata, who has fled today, Ekufuado and he, Godfrey Dami. But the rest, we can't stick out our necks. But the point is that you see that those cases dragged for long. If maybe we had plea bargaining laws that were working well enough, perhaps some of them, even if they were not guilty and they look at it and say, this money they are asking for, I have some. Well, I was in charge of Cuckoo Board. I supervised this contract and it went bad. But my friends and my family can help me raise this money, so I'll give it to the state and rest. Perhaps we could have raised money. We could have. So that's the more reason why the law should be there. We cannot take out this law. It will help us immensely. But remember Mr. Azim's point. He says, when you do the plea bargaining, let the people be informed, let them understand. And so in the same way, let's quickly remind Dr. Ayine, Attorney General, the Dufour one, the Unibank case, the one he accepted 60%. Where are we with the payments? We ask that anytime they do payments, Dr. Dufour and his family people, we should be informed. So this is the very thing that we want, open justice, transparency. That's the key thing. Let the people be informed. But as for the usefulness of the law, it's beyond question.
And then you mentioned that Ohene-Jan committed murder. His son just called us, distancing himself from that. He says his father never committed murder. I'd like you to retract that statement, and also, as Joy News, we disassociate ourselves from that statement. So I'll give you the opportunity to retract, please, and clarify what you mean.
It's not for him to decide. That is, he should read the case. It was a case of murder. Then he said he would take manslaughter. What did I say? I said, was he convicted for manslaughter or not? Is that not what we said? Oh, come on. He should. This is something that's taught in law school. Was he convicted for manslaughter or not? I didn't say he was convicted for murder. I said there was a case of murder, but he opted to take what? Manslaughter. So ask him, can you put him on? Did his father accept manslaughter, the responsibility for the death? Okay, so manslaughter means it was not intentional. You've caused somebody's death, but not intentional. But murder is you intentionally kill. When we say intentional, it's not as if we open the person's brain or mind to know, but we look at the acts. So, firstly, let's say touch wood. If you were to take a gun, touch wood, point at a simesi, and then you were to shoot, unless it can be shown that touch wood, you don't have any mental illness, unless it can be shown that you were mentally ill at the time you shot, it will be taken that once you took the gun, you pull the trigger, you intentionally kill the person. But when there is, what do you call it, mental illness, etc., it can be said that no, that's not murder, it's manslaughter. So you would have killed the person, but it is not murder, it's manslaughter. So what is the son saying? Did somebody die as a result of the father's involvement or not? That's all that we are saying.
Well, we don't have him on the line right now to have the banter with you, so we'd like to stay away from that.
You should be careful not to do such things. I mean, this thing is well over how many years now? What is he saying? I mean, come on.
Okay, let's move back to the conversation that with regards to the Exim Bank loan fraud case. I'd like to take your final words before I go to Andy Appiah-Kubi to get his final words as well.
Okay, so my final word. So I'm saying that I'm excited that he Wontumi wants to take this route. It's more efficient. It will bring quick justice, and then also it will give himself closure quickly. And I would also add that just as Appiah-Kubi has led Wontumi well to accept this, whereas Appiah-Kubi should reach out to Ofori-Atta, who has fled our jurisdiction, and we are struggling to extradite him, and indeed the whole of the MPP. They should bring down Ofori-Atta. He should know that there are such laws which are good. It's not always everything about jail. The law says if you bargain well, you will not even be prosecuted. The charges can be withdrawn. You can return the money. So perhaps Ofori-Atta and the MPP family should hear about this, and Ofori-Atta should be willing to come and face justice. That's very, very important. Because unless Ofori-Atta is brought down to face justice, MPP will struggle to convince Ghanaians that they deserve to run this country again in future. Because accountability is what we are faced with. If you are not accountable, you don't want to be accountable to the people, you cannot lead the people. So they should take a leaf from Wontumi's action and see how they can bring down Ofori-Atta quickly so that he too can take advantage of some of these laws.
Thank you so much, Martin Pebo. I'm told I don't have Andy Appiah-Kubi. I just wanted to find out when exactly they have a meeting with the AG, but when we reconnect our lines and we get him, we'll ask him that question. We appreciate your time, gentlemen. Earlier I spoke to Vitus Azim and then Martin Pebo, and as well as Andy Appiah-Kubi. Well, away from that, local government minister Ahmed Ibrahim has directed the Ayawasu Central Municipal Assembly to account for more than 400,000 Ghana cedis allocated to persons with disabilities after the assembly failed to provide the required expenditure records. The directive was issued during a ministerial monitoring visit to assess how assemblies are using funds from the district assembly's common fund. The minister says the exercise is aimed at enforcing accountability and ensuring public funds are applied strictly for their intended purpose. There is more in the following report.
By Friday, tomorrow, when we close, go to the administrator for this assembly common fund. Tell him that I say I want all the 4 advices for PWD for Ayawasu Central. When you receive them, go and be waiting for me in our office. By the time we close, you must meet me there.
The tour, led by local government minister Ahmed Ibrahim and his deputy, took the team to the Ayawasu West, Ayawasu North, Ayawasu Central, and Ayawasu East municipal assemblies. At the various assemblies, the minister inspected records on the use of the district assembly's common fund, with particular focus on the 3% allocation for persons with disabilities. But at the Ayawasu Central Municipal Assembly, the minister raised concerns after officials were unable to immediately provide full documentation on how more than 400,000 Ghana cedis meant for persons with disabilities had been utilized. He directed Assembly's finance officer to produce the relevant expenditure records, insisting that funds allocated for vulnerable groups must be properly accounted for and used strictly for their intended purpose.
President has given you money for persons with disability. He said you take it and disburse it for them, and you have received it. Shouldn't it be easier for you to account and say this is how much I received? Then you are telling me you have spent